And in it, Mr. Brian Molefe sought to rationalize to the board the justification for the increase.
For the increase, and in doing so, as to what covers, what contingencies are catered for, relocation is one of the items.
Even though the word relocation in the memorandum does not appear, yes, the subject of allocating the 2 OEMs to Durban is covered.
Okay. Thank you.
Under paragraph 12, the current status of the utilization of the contingencies budget is as follows. You will see that below, Chair, there is a description of what the contingencies have been approved for, and there is an amount related to each specific line item. Contingencies approved, 4.9 billion. Variation orders approved to date, 1.2 billion. Relocation of BT, 618 million. Relocation of CNR, 647 million. Then there is unutilized portion of contingencies amounting to some 2.519 billion rands.
Then, if I may, I'm sorry to interject. On the reading of paragraph 12, particularly in respect of relocation of BT and CNR, regard being head to the amounts, the budget referred to in here cannot be the budget of the business case because that was a year previous.
Indeed, Chair.
And that could not have been a budget spelled out in the memorandum of Mr. Molefe because that was in May 2014, and at the time, the relocation cost, at least insofar as CNR is concerned, was not 647.
Indeed, Chair, even though a specific amount was made out for contingencies, as it were.
Yes, for contingencies.
Yes.
So my question then is there any document that reflects this budget as set out in paragraph 12 by Ms. Lindlu Mdleche?
Apart from the first line item,
Yes,
which is set out, as we've said, in the memo dated 23 May
Yes.
2014, prepared by Mr. Brian Molefe, there is no other document that lists this budget.
so we're seeing it for the first time in this memo?
It's seen for the first time here.
Okay, thank you.
Thank you, Chair. Chair, if the Chair turns overleaf to page 9137, paragraph 13 reads, consequently, an amount of 647,181,494 rand is part of the contingencies budget included in the final approved estimated total cost of the project. Recommendation, paragraph 14 reads, request for the acting group chief executive to A, note the final outcome of the negotiations for the relocation to Durban with CNR. B, approve variation order for the relocation to Durban to a maximum value of 647,181,494 rands with CNR, and C, sign off a letter to be issued to CNR to accept the final proposal. Chair, what then appears below are the names of the people that want the compiler of the memorandum and the individuals that then recommended, as well as the approval signature by Mr. Kama, which is dated 23 July 2015.
So the memo was compiled by Ms. Lindiwe Mdleche, who signed. It was recommended by recommended by Mr. Ravi Naya, Acting Chief Executive, Transnet Freight Rail.
Yes, Chair.
It was signed by him on 22 July 2015.
Yes, Chair.
It was also recommended by Mr. Ndipiwe Silinga, Group Executive, Legal and Compliance, and signed on 22 July 2015.
Yes, Chair.
It was recommended by Mr. Anuj Singh, Group Chief Financial Officer, on 22 July 2015.
Indeed.
It was recommended by Mr. Tamsan Ngachiane on the same date and signed on the same date, as well as by Mr. Gary Peter, and then the following day it was signed by, approved and signed by Mr. Gama in his capacity as Acting Group Chief Executive of Transnet.
Yes, Chair.
Well, I don't know whether you have picked up something that I can't see or haven't been able to see in this memorandum. This memorandum seeks approval that a very large amount of money, about 647,000 rand, be approved for...
Million, Chair.
Million, Chair.
Million, yes. Million. Be approved to be paid for what is called a relocation cost. But I can't see anything in the memorandum where those who, Ms. Mdletshe, and those who recommend, and ultimately Mr. Gama who approves, which says, why is this amount a reasonable amount to spend on the so-called relocation? All I can see is the background and the fact that the amount falls within what was budgeted for under contingencies. But the fact that there is budget for an item is not justification for paying a certain amount for that item. You must still check whether that amount is justifiable. I haven't seen that here on this memorandum, so I wonder whether you have seen that.
Chair, we have not been able to see anything that speaks to either a critique of the final proposal or the final amount, or that justifies or details a support of the final amount which is being requested for approval.
Sorry, Chair, your mic is off.
Thank you. That this amount be spent on the so-called relocation is recommended by various senior people and approved by the acting group chief executive, without any of them asking this very critical question: would we be spending, would it be justified to spend so much money on this relocation, so-called relocation? How is this amount justifiable? Why is it 647 million rand and not 100 million rand? Why is it not 50 million rand? And nowhere here in this memorandum is that amount of 9 million rand that was first given by CNR mentioned, to say that's where we're coming from. Initially, these costs were estimated at 9 million rand, but now we are talking about 600 and something million rand, so that the full picture is shown. That's not mentioned.
It is not dealt with, Chair, not mentioned at all.
Now, in your investigation, did you find that Transnet, and maybe the previous witnesses would have dealt with this, I just can't remember now, do we have proof that Transnet did receive that estimate of 9 million rand, or acknowledged having received it and responded to it in one way or another that was made initially?
Chair, the best way to answer it, even though we did not have proof of email correspondence that responds to the offer of 9 million rands, the documentation that included that quotation of 9 million rands, which is addressed to Mr. PT1 and Ms. Lindiwe Mdletshe, was received from Transnet itself. It was received in particular from the supply chain services personnel at Transnet Freight Rail. When Ms. Mdletshe became the interface for us to receive information that was required to be perused for the course of our investigation. So the documents that we've perused came from Transnet.
So certainly it was received by Transnet.
Certainly it was received, Chair.
But were you only able to tell that supply chain management received it, but you didn't find any evidence that other people at Transnet, the GCEO, Mr. Gama, Mr. Mlefe, Mr. Peter, Mr. Anuj Singh, did you come across anything that suggested that they at least knew of this amount at some stage or another?
No, Chair. I would, however, would like to also point out that at the time that the quotation is sent was during the final stages of the negotiations.
Yes.
Yes.
The 9 million rand.
The 9.7 million rand
Yes.
is received a week prior to the conclusion of the negotiations, which were concluded on the 17th of March.
Oh,
That's when the agreement was then signed.
yes. And you haven't come across, have you come across anything that shows that the board was told of this 9 million rand
No, Chair.
quotation? You have not found anything?
No, Chair.
Okay, because it's important to find out, to establish that Transnet received this quotation of 9 million rand for this course. It's important to establish what their reaction was to it, because that becomes quite important for them to justify how they were reacting to offers of hundreds of millions of rands for something that they would have known at some stage produced a quotation of 9 million rand. And I think from what Mr. Mnyandu said, even with that 9 million rand, maybe should have been lower. I think so it's very important to connect all of these things. Who was aware of this 9 million rand quotation? What did they do about it? How do they justify approving 600 and something million rand afterwards? Where is the interrogation of these amounts that they were obliged to undertake on behalf of Transnet in order to protect Transnet's interests and the taxpayers' money?
Indeed, Chair. Perhaps on that score, then, let's just clarify at least now. Did you make inquiries, Mr. Mnyandu, from Ms. Mdleche, who's the author of this memo we just went through? And as you say, was the interface between Transnet and MNS during the course of investigations? Did you inquire from her whether she did receive the 9 million rand quote, original 9 million rand quote from CNR?
Chair,
And what was her response if you did?
Chair, I cannot recall with certainty whether that actual question was posed to her rather. Let me say this for the record, Chair, that as forensic investigators who are tasked with perusing certain documents, conducting certain interviews with personnel that were involved in a myriad of transactions, you are tasked with, number one, reading documentation and making necessary deductions. You have to reach certain conclusions, because it is not each and every witness that is going to be, one, willing to speak to you in the first place, but moreover, be willing to answer certain questions that would in any event seem as though you are laying blame or placing responsibility on them. The Chair will recall that in any event yesterday, we informed the Chair that whilst Ms. Lindiwe Mdleche at first, who was the lead interface insofar as the collation of documents was concerned for MNS Attorneys, might not have been hostile, but when it got to certain discussions, she was. So in explaining that, I'm trying to point out to the Chair that it is not each and every detail that would have been interrogated with her in order to reach certain conclusions. And having said that, I'd like to go further but not speak out of turn. In relation to the approval of these costs, Chair, you will recall that yesterday we took you through, prior to getting to this, an email sent by Mr. Gary Peter on 10 July, In particular, he requested that not only should she compile the documentation for the approval of the relocation costs, but that she should also get the sign-off from Transnet's internal audit team. The chair will note from page 9137, which we've just taken you through, that not only is it not signed by a representative of the Transnet internal audit team, but there is actually no signature line that was ever added to the memorandum. Yes, Chair.
No, that's understandable, and I accept that it's not all the questions that I might think of or Ms. Silo might think of that you and your team may have thought of, and not all the questions that we think of are questions that people watching from their homes can think of. There'll always be questions that somebody else thinks of that you might not have thought of, and that on its own, and depending on the question, on the nature of the question, and what your task was and what you had before you there might be no blame, So obviously there may be certain questions that are too obvious, so that if you don't ask them, people say, but what was he doing if he didn't ask this question? But at this stage, I understand, understand that there are certain questions that you may not have asked. But of course, there are some that even if a witness is hostile, if they're important, you have to ask. And if they don't answer, and you have no power over them, you just record that they didn't want to answer. But
Indeed.
yes, no, that's fine. So we might have to look at all of these things to really establish who knew what, who knew about this
Yes, Chair.
9 million rand quotation, and later got to know about over 600 million rand for the same thing.
Yes, Chair.
And why was the 9 million rand not accepted? But as Mr. Mnyandu implies, even that 9 million rand shouldn't have just been accepted. They should interrogate everything that has got cost implications for Transnet and for the taxpayers.
Indeed, Chair.
Yeah.
And the Chair will recall that that 9 million rand quotation was first introduced by Mr. Gonzalez. We will go
Yes.
back to Mr. Gonzalez's
Yes.
files and see how much of the question we can begin to answer. And to the extent that we still have a gap, then our investigators will be requested to see if they can close that gap.
Yes, no, thanks. And I don't know if we asked Mr. Gonzalez, but we need to know whether from his side he knows any reaction that may have come from one or other official from Transnet in regard to it.
We will determine that through the papers and the
Yes.
transcript, and if the question was not posed, we
Yes.
perhaps may pose it to Mr. Gonzalez,
Yeah.
and to the extent necessary, he will file a supplementary statement
Yeah.
in that regard.
Yeah, that's fine.
Thank you, Chair. Yes, Mr. Mnyandu, we may proceed.
Thank you, Chair. It is now necessary for us to move to slide number 29 to take you through the memorandum prepared in respect of BT. The memorandum was prepared on the very same day. It is to be found at Appendix 15, which is contained in Volume 13 of the Chair's files at 9129.
Yes.
9129 being the covering page and the document beginning at 9130. Chair, I will read the memorandum just like I did with the previous one.
Yes.
The purpose is to, one, request the acting group chief executive, in brackets GCE, to A, note the final outcome of the negotiation for the relocation to Durban with Bombardier Transportation SA, in brackets BT. B, approve variation order for the relocation to Durban to a maximum value of 618,457,125 rands, with BT And C, sign off a letter to be issued to BT to accept their final proposal. Below that, it says the background. On 17 March 2014, Transnet, acting through its Transnet Freight Rail Division, in brackets, Transnet Freight Rail, entered into various locomotive supply agreements with CSR, CNR, GE, and BT after negotiations which started in February 2014. During negotiations, BT and CNR were informed that they will use the Durban Transnet Engineering, in brackets, TE, close brackets, facility for the construction of the locomotives which were allocated to them. The Durban facility and the move were introduced to both CNR and BT after the tender had closed and evaluations were done. Number 4, on the 10 June 2015, the acting GCE, Group Chief Executive, approved the team to negotiate the relocation to Durban with Bombardier Transportation SA. 5, TIA was present at the negotiations and are in the process of finalizing their report. Below that is the motivation. Paragraph 6 reads as follows. Bombardier's final offer to Transnet is an additional discount of 2.5% and the following cost which has been absorbed. A, further price escalation. B, financing cost of own additional efforts, suppliers, and already accumulated stock. And C, claims from the suppliers that BT has already rescheduled and delayed. The chair turns over leaf. It says A, further price escalation. The cost of the further price escalation of material, labor, and other expenses were evaluated at 4% due to the additional time for deliver. 2.5% was due to the increase of the euro-rand ratio over the last year since the instruction to change Transnet Engineering Facility was received from Transnet Freight Rail, and since Bombardier Transportation submitted the first notice of company proposed variation on the subject. The additional financing cost due to our ongoing expenses on the internal efforts and cost from our suppliers in addition to the logistics and warehousing cost, negative cash flow, in brackets, create an additional 2.5%, in brackets, 2.5%, of the cost. In addition, the escalation mentioned above, claims from suppliers, were costed at 1%, in brackets, 1% full stop.
Can I just inquire, at times under A at page 9131, the section you just read, there's reference to our. Do we interpret the our to be reference to CNR and not our Transnet? So it's not Transnet speaking here.
It seems to reference BT's.
BT rather, sorry.
Yes, Chair.
So it's seemingly a direct quote from the BT proposal.
Indeed, Chair.
Thank you.
If the variation order is not issued by 24 July 2015, the value of BT's notice of company proposed variation order will increase by 20%. BT's current offer represents a total discount of 32.5% when taking into consideration the indicated potential price increase of approximately 20% in instances where, by the notice of company proposed variation or the VO, is not approved by TFR by 24 July 2015, in brackets, validity of BT's offer. The 32.5% is the sum of the 10% absorbed cost of further price escalation, the above-mentioned 20% increased price after the 24 July, and a further 2.5% discount given by BT. The following payment terms have been proposed by BT in accordance with Section 1.2 of Schedule 1, in brackets, pricing and payment terms, of the Locomotive Supply Agreement. It quotes the first two milestones, in brackets, the effective date and the 6 months after effective date, close brackets, amounting to a combined total of 18% of the total contract price of all locomotives, have already been achieved, due, and will be invoiced by BT once the variation order is issued. The third milestone payment to the value of 9% of the total contract price of all locomotives will be due 17 months after the effective date and will be invoiced accordingly. Chair, what follows below, even though the wording is not clear, we know this from previous email correspondence that was needed to be checked by the legal department, is what this would mean, what changes would need to be effected to the locomotive supply agreement. 1, definition, TE facility, as it reads currently, Kurusport Gauteng, amended to definition, TE facility, Durban, KwaZulu-Natal. 2, clause 9.1.1, as it reads currently, clause 9.1, if the acceptance of a locomotive occurs after its scheduled acceptance date, in brackets, a delay, the contractor shall, subject to clause 9.2, in brackets, delay penalty cap, pay a delay penalty to the company in respect of the delayed locomotive at the applicable rate. A delay penalty grace period for 3 months shall apply to the initial 6 locomotives scheduled acceptance date. Amendment to clause 9.1. If the acceptance of a locomotive occurs after its scheduled acceptance date, in brackets, a delay, the contractor shall, subject to clause 9.2, in brackets, delay penalty cap, pay a delay penalty to the company in respect of the delayed locomotive at the applicable rate. A delay penalty grace period of 3 months shall apply to the initial 35 locomotives scheduled acceptance date. An additional grace of 2 months shall apply to the remainder of the fleet. Budget implications. Under paragraph 9, it reads, the board at its meeting of 28 May 2014 approved an amount of 4.9 billion rand in contingencies as part of the revised estimated total cost. The contingencies budget were to cover the following items. A, capital spares beyond the warranty period. B, variation orders and options, in brackets, such as electronically controlled pneumatic braking and wire distributed power. And C, relocation of the program to Transnet Engineering's Durban facilities. Under paragraph 11, the current status of the utilization of the contingencies budget is as follows. The chair will recall that this was a table referred to in the previous memorandum. Under paragraph 12, it says, consequently, an amount of 618,457,125 rands is part of the contingencies budget included in the final approved estimated total cost of the project. And if the chair turns overleaf at page 9133, there is a recommendation. Under paragraph 13, request the acting group chief executive to A, note the final outcome of the negotiations for the relocation to Durban with Bombardier Transportation. B, approve variation order for the relocation to Durban to a maximum value of 618,457,125 rands with BT. And C, sign off a letter to be issued to BT to accept their proposal. As the chair will then note, the memorandum is also compiled by Ms. Lindiwe Mdletshe. She has signed it, but has not dated. Mr. Ravi Nair, acting chief executive at Transnet Freight Rail, who signed it on the 22nd of July 2015 in recommendation. It was also signed and recommended by Mr. Ndipiwe Silinga, group executive, legal and compliance, on the 22nd of July 2015. It's also signed and recommended by the group chief financial officer at the time, Mr. Anosh Singh, on 22nd July 2015. Also signed and recommended by the then chief executive of Transnet Engineering, Mr. Thamsanqa Nqatjiyane, on 22nd July 2015, as well as Mr. Gary Peter, Group Chief Procurement Officer, on 22nd July 2015. And then below that is the approval signature of Mr. Siyabonga Gama on 23 July 2015.
Thank you. Before we leave that memorandum, I would like to take you back to page 9131. At 9131, under the heading A, further price escalation, you read 4 items, and at times it would appear that it's a direct, as you confirmed, I think, a direct quotation from the BT proposal.
Indeed, Chair.
Now, I would like to refer to the paragraphs that follow that. There are 2 paragraphs, the first starting, if the variation order is not issued by 24 July, and subsequent. can I take that to now be the drafter of the memo speaking? It's no longer a quotation, direct quotation from the proposal.
It's drafted in that manner, but it comes from the letter sent by BT to Transnet.
But now this is what Ms. Mdletshe, as a drafter, is informing.
Communicating.
Yes.
Indeed, Chair.
I'm interested in the paragraph thereafter, and I want to see whether you considered it in your investigations and whether you got a clear understanding of it, and if so, to share the understanding with us. It reads, BT's current offer represents a total discount of 32.5% when taking into consideration the indicated potential price increase of approximately 20% in instances where the notice of company proposed variation or the VO is not approved by 24 July 2015. I have gone back to your slide 19, where you have listed the various price offers given by BT. The highest was 634.
Indeed, Chair.
The highest known, and the accepted offer, the lowest was 618 million, which turned out to be the accepted offer.
Indeed, Chair.
I'm trying to understand this 32% discount. Where and how do I factor it in? I don't know if, unless my mathematics is failing me. If you go to your slide 19, you will see the prices compared.
Chair, it is not explained.
Okay.
In fact, if one has regard to Exhibit BB8
Yes.
and at page 95,
Just 1 second, please.
yes, Chair.
Okay, all right.
You now want us
where
to
are
turn
we?
to?
Which page are we going to?
We are back
And
to-
Just tell me again what the question was.
The question, Chair, emanates from page 9131 of volume 13, the volume at hand. There is reference in that memorandum where it is stated that the Bombardier's current price represents a total discount of 32.5%. I then referred Mr. Mnyandu back to page 19 of his slide, which has shown us all BT's cost offers. The highest coming in at 634 and the lowest coming in at 618 million. It is against that background I seek an understanding as to where the 32.5% saving is to be found, accepting that perhaps I may have made an error in my mathematics. Mr. Mnyandu, in attempting to answer that question for me, has referred us now to BB8C, that is the slide file,
Oh, okay.
and he has referred us in particular to page 95.
Okay.
That will be under tab 6, Chair.
Yes, I've got it, thank you.
Okay, we have located TTM 6.
Chair, Ms. Silo says in attempting to answer the question when I am actually trying to compound the confusion even more.
Oh, okay, I was overly optimistic there.
I guess you are answering it by compounding it.
Chair, this is a letter sent by Bombardier Transportation. It is dated 7 July 2015.
Yes,
It is the covering letter of what was the final proposal sent by BT, which, as we have explained to the Chair, didn't change materially, but for what is recorded in the letter. It is addressed to Transnet Freight Rail. It is for the attention of Ms. Lindiwe Mdletshe, as well as Mr. Friki Harris. It says, copy to Mr. Anosh Singh, Mr. Tamijiane, Mr. Gary Peter.
yes.
It's entitled Price Reduction on the Notice of Company Proposed Variation. Durban VO. Dear Lindiwe, stroke Friki, we refer to our last notice of company proposed variation submitted to Transnet Freight Rail.
Or rather latest, eh?
To our
We refer
latest
to
note.
our latest.
Latest.
As opposed to last.
Oh, apologies. We refer to our latest notice of company proposal variation submitted to Transnet Freight Rail, in brackets TFR, as per our correspondence, which has a reference of BT, stroke TFR, stroke C, stroke 15, stroke 0034, dated 10 April 2015. As discussed into our ongoing discussions.
Or described.
Oh, described.
Yeah.
Into our ongoing discussions, Bombardier Transportation has endeavored to minimize project impact from the change of TE facility from Gurasport to Durban. As a further show of good faith, BT is willing to offer an additional discount of 2.5%. In evaluating the discount, please take into consideration that this reduction in reality is much higher due to the fact that since our first offer notice of company proposed variation in 2014, we have already absorbed the following: costs, further price escalation, financing costs of our own additional efforts, our suppliers and already accumulated stock, and claims from the suppliers that we have already rescheduled and delayed. The revised amount after the 2.5% discount will be 618,457,125 rands. Chair, for the purposes of what we are trying to communicate, we can stop there in reading this letter. But even on BT's own account, insofar as this letter is concerned on 7 July, which notes the final offer made, there is no talk or mention of a discount amounting to 32.5%. Yes, Chair.
So it's 2.5%.
Indeed, it is so, Chair.
So I guess it's a question of the author will explain to us where the 32.5% discount is derived from,
Yes, Chair.
because that is what is communicated to the acting GCE.
Yes, Chair.
But,
Bef-
oh, yeah.
Before we get there, though, was there any documentation you were able to come across in the course of your investigations that would support a claim of a 32.5% discount?
Well, I would like to say to the Chair at this moment that, as we said yesterday, there is documentation sent by Bombardier Transportation towards the end of 2014,
Yes.
which will be provided to the Commission, which sought to be explanatory or letters that were expanding on the offers of Bombardier Transportation to Transnet.
Yeah, but yes, I understand. But an analysis of that very documentation together with what we have before us, were you able to establish definitively that the negotiations have resulted in a 32.5% discount?
No, we were not.
Okay. Thank you, Chair.
I think you made the point that the memorandum that you were reading talks about a certain discount. Is that right?
Yes, Chair.
A discount which you say can't be found in this letter from BT. Is that right?
Yes, Chair.
In terms of the amounts, once they talk about different figures, that should affect the amounts. Does it affect the amounts, the final amount, or does it not affect? I just haven't looked at it. The amounts that they talk about in the memorandum in regard to BT compared to the amount BT talks about in this letter, where they don't mention this other discount that the memo talks about.
Chair, if one has regard to the fact that the first offer in September 2014 is some 634 million rands odd, a 32.5% discount would be much more significant than the amount moving from 634 to 618.
Yes,
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 Chair.
yes. But you didn't do the exercise of establishing exactly what the amount would be, the real amount.
No, Chair, we didn't do the exercise based on the
Yes,
32.5%.
Okay, so I think it would be important for somebody to do it if we haven't done it also.
Chair, it would be an arithmetic exercise, really.
Yeah, it's an arithmetic exercise,
calculator. The
Yeah.
first offer is 634.
Yes,
The last and accepted offer is 618 million.
yes.
Now, one can work out on a calculator what that represents by way of
Yes,
percentage
that's
as a
what I'm
discount.
talking about, yeah.
What I was trying to determine is there another figure we are missing
Yeah.
that if we incorporate into the calculation will give us a 32.5% discount?
Yes,
Because
yes.
whatever discount there may be from 634 to 618 is not 32.5.
Yes.
That would bring us closer to the 400 million mark if it were.
Yeah.
Yes,
No, what I'm looking at is to see whether there may have been some genuine error somewhere by somebody, or whether there is much more to it.
We will, Chair. It might
Yeah.
be instead of 32.5, it might be 3.25.
Yeah,
We will do that calculation, Chair.
okay.
Thank you. And Mr. Mnyandu, you make the point that both the BT and the CNR memoranda to Mr. Siyabonga Gama were approved on the same day.
Yes, Chair.
So the costs of relocation as quoted by both were accepted by Transnet.
Indeed, Chair.
You may proceed then from there.
Chair, having taken you through the approval process followed, we now deal with the involvement or the limited involvement of Transnet internal audit.
Before we do that, what it does mean is that when you put the two amounts approved for both BT and CNR, then you have about what, 1.4 billion?
It's an aggregate amount of 1.2 billion.
About I think it should be about more than that. Both are more than 600 million.
647 and 618.
Yeah.
Yes.
So or is it just under 1.3?
It's just under 1.3.
Yeah. Okay. All right. For the relocation, for the so-called relocation costs.
Of both OEMs, yes, Chair.
Yeah. Now, before we proceed, let me ask this question. When you look at both memoranda,
Yes,
the
Chair.
one from CNR and the one from BT, they appear to say, look, this money that we are asking you to approve has already been, or falls under contingencies that have already been approved. So it's really not a problem, you know, just approve, okay? And it looks like then Mr. Kama is satisfied and then approves.
Yes, Chair.
So now, since we know that from the memoranda that were sent to him, both in regard to BT and in regard to CNR, did not really include motivation by the compiler of the memoranda as to why those amounts were acceptable. The question would be whether, when contingencies were approved, there was anything that related specifically to this so-called relocation, or whether contingencies were simply approved on the general basis. Whatever contingencies may come up, they should be taken care of under this amount that we have put aside, 4-something billion, as I recall. So, is that something that your team looked at as to see whether one can say, look, the approval of the contingencies, the information that was up before those who approved contingencies was such that there was no need, when this request was made, to interrogate this issue more, because it had already been dealt with. Is that something that you looked at?
Chair, I would like to draw your attention to the fact that we have said the 23 May memorandum prepared by Mr. Brian Molife, insofar as it relates to 4.9 billion rand for contingencies, it makes mention of the use or the allocation of Transnet Engineering's Durban facility in order to stimulate, amongst other reasons, the economic trade of South Africa along the coastline. However, there is no line item that speaks to a certain number that then budgets for the relocation,
No.
in inverted commas. However, Chair, even if there was, our view, based on the findings we have come to and what one would expect from standard contract management protocol, even if it was, that an exact amount of 1.5 billion rand had been set aside. That would not excuse Transnet and its officials from reviewing, critiquing, and seeking a justification from each of the OEMs for the costs. One certainly does not work from the premise that there is 2 billion rand in the kitty, and therefore, if one claims 1 billion, which is 50% of that, I'm going to be comfortable with it. It is something that we considered, and we came to that conclusion.
Yes. No, one would really expect them to interrogate these issues, but I'm just trying to see what kind of possible justification they might have, because it's a lot of money, and you expect that they, any memoranda that seeks to say such big amounts must be approved would deal with why it's acceptable to pay in the first place and why it's acceptable to pay the particular amount in the second place. How is that amount made up? What are the items? And that's lacking in both memoranda. So, yeah, okay, thank you.
Thank you, Chair. It is, as the Chair states, and the reasons perhaps might be advanced at a future date when the Chair has the opportunity to talk to some of the drafters and the approvers of these memoranda.
Yes, no, we will have to hear from them. It's a lot of money, and as Mr. Mnyandu says, you don't expect people to say, look, there is budget for it, so we can just pay.
Indeed.
Yeah,
Indeed,
okay.
You are now turning your attention, Mr. Mnyandu, to the involvement or non-involvement of TIA.
Indeed, Chair. Chair, just as an overview, we cover this in our report. The Transnet Procurement Procedures Manual, which was applicable at this time, of Volume 3, 2015, requires that for any contract negotiation or variation that exceeds 50 million rand as an estimate must involve the high-value tender team, which is Transnet Internal Audit, who must undertake through each and every stage of such negotiation what are called gateway reviews. You will recall, Chair, that when we took the Chair through the transcript of the meeting held, rather the meetings held with each of the OEMs on 19 June 2015, there was a representative from the high-value tender team or the Transnet Internal Audit team. Chair, we've got a report from Transnet Internal Audit dated 7 June 2017. It is to be found in volume 13 of at page 9147. It is not necessary to take the Chair through the report because in the slide we highlight the salient parts. They confirmed that they attended the initial meeting held, or rather meetings held with each of the OEMs on 19 June 2015. The report specifically records that the lead of the negotiations, Mr. Arnold Singh, who was the Group Chief Financial Officer at the time, requested that the bidders submit revised proposals that would explain their offers in more detail. And the report also confirms that a follow-up meeting was then scheduled for 23 June 2015 for further negotiations. The report also then records that unfortunately, Transnet Internal Audit was not invited to subsequent meetings where the negotiations for the relocation costs then continued. The report also makes mention of the fact that a representative of Transnet Internal Audit, Ms. Emma Moletsane, was copied in the email correspondence of Mr. Gary Peter on 10 July 2015, in which, as we have taken the Chair through this morning, there was a request that Transnet Internal Audit sign off on the, to use the word loosely, the prudency of the costs of relocation, having confirmed that the necessary gateway reviews were undertaken. As we've taken the Chair through it, it is made mention of in the report that that request for a signature, a review, never came through to Transnet Internal Audit, and therefore the report concludes by saying that unfortunately the Transnet Internal Audit team is not able to confirm that indeed the process followed was in accordance with what is required by the Procurement Procedures Manual.
And I see at page 9147, which is the actual report, it is addressed to Mr. Siyabonga Gama, the Group Chief Executive.
Indeed, Chair.
So it's a report by internal audit for Mr. Siyabonga Gama, and dated June 2017. At page 9152, which is the signature page of that document, I see Mr. Siyabonga Gama has signed it, which means he became aware of its contents.
Indeed, Chair.
Understanding then that TIA's involvement in this entire transaction was minimal to none. Understanding from this report that there is no confirmation that what you call gateway reviews were conducted at all relevant points or junctures. Do you know what Mr. Gama's response or reaction to this report was?
Chair, it is actually at page 9152.
Yes.
Apart from noting it, and it is dated that he noted it on 8 June 2017, he has scribbled a note, and I'd like to read it into the record for the Chair's benefit.
Yes.
In a letter to Acting Group Chief Executive on 23 July, reference is made to the effect that the high-value tender report is being finalized. I would like that the HVT report is produced. Further, all information required for same must be made available to the CAE, which is for Chief Audit Executive. The Chair will see that next to Mr. Siyabonga's signature is the name Ms. Mathabo Sukati, who was the Chief Audit Executive, and she has signed. Chair, the letter that Mr. Gama refers to in this regard can only be the two memoranda that we read for the Chair for the approval of the costs. The Chair will remember that under background and just before motivation, it notes that TIA, Transnet Internal Audit, was part of the negotiations and they are finalizing the report.
So I see now where Mr. Siyabonga Gama has signed, it reads now Group Chief Executives, Group Chief Executive. And this is June 2017, and by this time he had been a permanent appointee to that.
Indeed, Chair.
So when he says in the note, in a letter to AGCE, that's Acting Group Chief Executive, who is he talking about?
He's referring to himself, Chair.
Oh, he's speaking about himself in the third person?
In the third person.
Okay, understood. Besides that note, do you know whether Mr. Gama took any particular steps in regard to the process followed and the concerns raised here, or recorded in any document what he proposes be done about non-compliance, which I think this report constitutes?
No, Chair.
So your investigation did not find anything suggesting that the high-value team report that he said should be made available to CAE, namely the Chief Audit Executive. You found no evidence that it was made available to the Chief Audit Executive?
We found no record, Chair.
Yes.
Yes.
Did you ask the particular Chief Audit Executive whether is it a she?
Indeed, it is a she.
Yeah, she ever received it?
Yes, we did ask,
Yeah,
but it was never received.
yes.
Yes. Chair, I would just like to note as well that the note in itself and the request, to use a word used by the Chair yesterday, is strange.
Yes.
It is strange for the reason that the report from Transnet Internal Audit records that in light of the fact that we have not been able to fully partake in the negotiations out of not our fault, we are unable as the internal audit team to provide assurance that the process was followed out in accordance with the spirit and purpose of what's contained in the procurement policy manual.
Okay. When and where do they say that? Is that something where we have just dealt with, or is it one of the things we didn't read? In relation to this letter, to the date of this signature by Mr. Gama, when was this, when they said this?
Chair, this was in 2017. It's 7 June 2017. It is something that we did not read into the record, but if the chair is able to, would like to turn your attention to page 9151.
Yes,
Chair, I would just like to read the conclusion.
yes. This is just this is a memo from Transnet Internal Audit addressed to Mrs. Siyabonga Gama, Group Chief Executive, and what date? There's no date given on the first page. What date was it
Chair,
written?
the first page notes a date at 9148 as 7 June 2017.
I'm sorry?
7 June 2017. There is a stamp on the right-hand side. On the left-hand side, it's
At 9148.
9148. Apologies.
Oh. So it was received by the office of the Group Chief Executive, which would have been Mr. Gama at that time.
Yes, Chair.
It was received on the 7th of June 2017, and it was coming from the internal audit. Is that right?
Indeed, Chair.
Okay. So now we know that's June 2017, and that's June 7. So he is making this note the following day.
Yes, Chair.
He might or might not have seen it yet, isn't it?
I beg yours, Chair.
He might or might not have seen it yet. What do you say? If it arrived the previous day in his office, and he signs this memo the following day, we don't know whether it had reached him. Or am I missing something?
Chair, he comments on the actual memorandum.
He comments on this is the memorandum he's commenting on.
Yes, Chair.
Okay, in a letter to, on 23 July, a reference is made to the fact that the HVT report is being finalized. I would like that the HVT report is produced. Is this the HVT report?
Indeed, Chair.
In his note that we are talking about, below his signature, excuse me, he talks about a letter to himself, as you have told us, which is dated 23 July. This is not this note at 9148, 9149.
Chair, can we take it to 9148?
Yes, I am at 9148.
The subject reads HVT.
HVT negotiations for Durban relocation, yes. CNR Consortium and PT Bombardier, yes. For your approval stroke signature, comments. You might be able to read that better, that handwriting. Eddie Thomas, or stroke Gary Peter, kindly ensure that all information that was required for the HVT report is produced or be produced, is made available to the CAE in order for the HVT to finalize its report. So who is writing there? Because that is addressed to Mr. Gama, isn't it?
Yes.
Yes, Chair.
But when you go to his note on page 9154, 9152, he seems to repeat that.
Yes, Chair.
Is that why you say he's commenting on it?
Yes, Chair.
No, okay. But the letter of 23 July is some other letter.
Chair, as we have said, we haven't found a letter of 23 July.
Yes,
It can only be, in our deduction,
yeah,
the two memoranda that were prepared for him in respect of BT and CNR respectively,
okay,
for
yes,
him to approve the relocation costs.
okay.
We
and-
say so because in the memorandum, it is recorded that
Yes,
Transnet internal audit
yes,
was part of the negotiations
yes.
and is completing its report.
Oh, okay, okay. So, and those were signed on the 22nd. So
Tho-
he might just have made a mistake by saying 23 instead of 22.
Yes, they were compiled on the 22nd, and
Yes.
everybody that signed and recommended did so on the 22nd.
Yes.
He signed them off the next day on the 23rd.
Or he signed on the 23rd, so that
Yes.
may be the reason why he uses
Yes.
23rd.
Indeed, Chair.
Okay, so what do you make of his, you were making a certain point about his note below his signature at 9152. And
Yes.
that is what triggered my questions.
Yes.
Yes, there's a point you were making.
In order to try
You're saying
and,
it was strange that he made this note.
yes, Chair.
Yeah, just repeat that point.
And we would like to take you to 9151.
Yes,
The request was that we read for you, Chair, the conclusion.
yes,
There are 3 paragraphs. They read as follows. TIA was not invited for subsequent negotiation meetings where negotiations on relocation costs were discussed with the bidders in attendance as required per the high-value tender methodology. Paragraph 7, despite the Group Chief Supply Chain Officer's request for Transnet internal audit to sign off on the memo that was to be sent to the acting Group Chief Executive for approval, Transnet internal audit was not provided with the memo or the outcome of the negotiations or the letters of acceptance of the proposals by the acting Group Chief Executive. Finally, paragraph 8 records, based on Transnet internal audit's limited involvement in the process indicated above, a formal report to indicate adequacy and/or effectiveness of the process undertaken in the Durban relocation negotiations could not be produced.
Oh, now I see the point you were making. You were saying, how could he be talking about the production of that report? Because he had just been told in that memo that TIA could not produce anything because of their limited involvement.
Yes, Chair.
Okay, no, thank you.
So then following on that, what one would expect from a group chief executive is to engage with the conclusions and the consequences. The conclusions drawn at 6, 7, 8 by the internal audit, and then to address himself to the consequences of the exclusion of internal audit from the process.
One would expect so, Chair.
Is there any documentation that would reflect that he did?
No, there isn't.
Okay. Are you aware of whether or not Mr. Siyabonga Gama ever made any follow-up either on this report or the note he makes on the report itself?
No, Chair, we are not aware.
Okay. If that's all you intended to highlight on the internal audit report, we're ready to proceed, but I think the chair might have a question or two on the report still.
No, we can continue.
Thank you.
Thank you, Chair. Chair, prior to taking you through slide 32, I'd like to give you context as to how it came about that we instructed the people that we instructed on behalf of Transnet to conduct an assessment of the relocation costs and the negotiations. Having formed a prima facie view on face value that the costs for relocation of both OEMs were excessive, we deemed it prudent to acquire the services of a rail logistics company that also is in the business of manufacturing locomotives and would therefore have the necessary knowledge on how much it would cost to set up production lines in the coast. We then instructed Loliwe Rail Solutions, a team led by Mr. Kevin McGill of the company, to conduct an assessment for us and provide a report on the final proposals accepted by Transnet in respect of the relocation costs. Chair, this is to be found in volume 13 at page 9446. What we have tried to do for the Chair in slide 32 is to summarize the salient findings made by Loliwe Rail Solutions as an independent expert, as it were, which supports the prima facie view or views that we held in relation to the relocation costs approved and accepted by Transnet. And basically, Chair, Loliwe Rail Solutions, in their report, come to the following conclusions: that there was no relocation of either OEM, that the variation orders were inflated intentionally by the OEMs and inadequately evaluated by Transnet prior to the conclusion and approval of the amendment of the contracts, that there is no justification for either the direct or the indirect costs presented by BT and CNR, that it was improper for Transnet to have agreed to lump sums for the relocation. The Chair will recall that when we took you through the memorandum of, in respect of CNR, there was a request that CNR be paid an upfront payment of 323 million rand, which is 50% of what had been agreed to. That the approval of the direct and indirect costs was done without the presentation of valid and substantiated documentation. And finally, that the process followed in the approval of the relocation costs was not in accordance with the standard contract management protocol. Just on the last point, Chair, we'd just like to draw your attention to the fact that when reference is made to standard contract management protocol, it is not a drafted standard by anybody or approved and gazetted by anybody, but it speaks to the norm in the industry of manufacturing, construction, and engineering. And what it actually points out is to the fact that if there is to be a variation that the parties accept is going to increase in cost, because in certain instances, what only increases is the duration of a contract or a project. If there is to be an increase in cost, then there is an agreed amount that is reached, or rather reduced to writing, and people or contractors alike then claim on proven cost to say, this is how much we agreed upon, this is what I have now produced, here are the invoices related to the particular claim, and therefore you need to pay me this certain amount. Chair, arising from our prima facie view, as well as the findings of Loliwe Rail Solutions, we then take you through our findings, which is the conclusion of the presentation, and note to you our recommendations to Transnet.
Well, you've said something about invoices, and I was still to ask whether, apart from the fact that the two entities gave their quotations, and there were terms of payment that they put forward, which Transnet agreed to. Payment ultimately, when it was done, was it done on the basis of any invoices and supporting documents and so on? Here I have in mind that if you have had to buy some material which are for this so-called relocation, you can produce what you have spent on them.
Chair, without speaking out of 10, because we have been advised by the evidence leaders
Yeah,
that a witness from Transnet
yeah,
will come and testify as to the payments done.
yes.
We can confirm that insofar as firstly CNR is concerned, an invoice was drawn up for an amount of 368 million rand. This is inclusive of tax at 14% at the time, and it was subsequently paid. The details in relation to payment will be, as we say,
Yeah.
expanded upon by a different witness.
Okay, no, that's fine.
Insofar as BT is concerned, we can confirm that as at the date on which Transnet took the decision to stop making payments in relation to the two variation orders, an amount of 248 million rand, 710,000 had already been paid in respect of its relocation costs.
Okay, thank you.
Thank you. That then leads you to MNS's own findings.
Indeed, Chair.
May you proceed.
Chair, the first and the most obvious finding that we have made is that the relocation costs were excessive. I would just like to add to that, Chair, that it seems Transnet communicated to both OEMs that they would be located at a different facility as opposed to the Kurasport that had initially been proposed or spoken of. It is not clear as to why Transnet then chose to lock itself into agreements that would necessitate the execution of variation orders. As I say, Chair, it is not clear and we have not been able to find the reason for this, but it was certainly not prudent to conclude the agreements on the basis of one aspect that is clearly not going to be beneficial for Transnet. Chair, insofar as the approval of the relocation costs are concerned, we have found that the former group chief executive at the time, Mr. Siyabonga Gama, breached the provisions of Section 76(3), subsection 3 of the Companies Act, insofar as he was required to exercise fiduciary duties and to take particular care and be diligent insofar as the execution of his duties are concerned, in that he authorized the expenditure of an aggregate amount of 1.2 billion rand without satisfying himself as to the cost analysis that had been done by his team that negotiated on behalf of Transnet or a third party that would have been appointed by Transnet. Chair, this would have been reasonably expected of a group chief executive, a person in his position, who had been with Transnet at the time for well over 15 years, had served not only as the group chief executive, but had the knowledge and expertise, experience of being the chief executive of the particular operating division that was making the acquisition in this regard. We have found, Chair, as a result, that a portion of the amount, which unfortunately cannot be quantified, and it cannot be quantified for a reason I will explain, amounts to fruitless and wasteful expenditure. Because, Chair, you raised a question earlier on and you requested that I deal with it before concluding the evidence. It is accepted that the tender proposals were based on one understanding. It could be accepted by two parties. There is no entitlement, but it could be accepted by two parties contracting at arm's length, that as soon as you change something as significant as my location, then my price might change. As I say, Chair, if it has not been provided for in the contract that we have signed, then it must be dealt with by way of a variation order. It having been accepted, it would then have to have been quantified properly. In this case, we found that it was not. When one reaches the conclusion that the relocation costs were unjustifiable and therefore excessive, there is the incurrence by Transnet of fruitless and wasteful expenditure, which is contemplated by Section 1 of the Public Finance Management Act. Chair, we have also found that the critical aspects of the advice that had been given by PwC during the beginning of 2014 was not carried through. You will recall, Chair.
Maybe it might be convenient that I ask you question in relation to what you have just dealt with before you proceed.
Yes, Chair.
So in relation to this, the use of relocation, from what you are saying, it would seem to me, and I would like your comment, it would seem to me that a relocation may have been just a wrong term to use, but there would be legitimacy to any extra costs that may have to be discussed and negotiated, that may have had to be discussed and negotiated between Transnet on the one hand and CNR on the other, and between Transnet on the one hand and BT on the other, arising from the fact that Transnet said you are now going to have to do this job from Durban and not from Gauteng. It seems that to the extent that that would give rise to certain costs, there would be nothing wrong in principle in the idea that there would be additional costs. What would remain is whether those costs are reasonable and whether processes are followed that are supposed to be followed before those costs are approved and paid. Does that accord with your understanding?
Chair, I would like to say, instead of a statement that says they would have been, I would qualify it by saying they could have been.
Yes.
And I say that, or rather we reach the conclusion on the basis that it could very well be that we contract on the basis of 54 million rand per locomotive, and your base price and everything that you've included into the tender proposal or the agreement reached is actually reduced by your location. So it does not.
No, I think we are on the same page. What I'm saying, talking to the principle, so you still have to justify the cost, but in principle, if the agreement was you will operate from here, and then later on there is a decision to say no, you have to operate from somewhere else, in principle there is no problem with there being a difference in price or there being a possibility of higher costs, more costs, extra costs, but they must still be justified. If you are being moved from Pretoria to Johannesburg, the cost might be minimal, or maybe there might not be any. But if you are being moved from a place that is closer to one that is much further, there may be more cost, but each item of cost must be justified. I think that's what you probably are saying as well.
Yes, Chair.
Yes.
Correct.
Yeah.
Agreed in full.
Yes, the principle that there could be extra costs has no problem.
Yes, Chair.
The question is whether those costs, if they do arise, are justifiable.
Indeed, Chair.
Yeah. Okay, all right.
And then if I may just follow up on that, Mr. Mnyandu, but if the RFP and the contract subsequently concluded says you let's say the RFP, you are required to bid for production of the locomotives in Kudesport or any other location in South Africa, and read that as a complete term. If it read that way, one would expect that in calculating your costs as a bidder, you would take into consideration that the site for production might not necessarily be Kudesport and might be another position in South Africa, and you will have catered for that eventuality. Would that be an unreasonable expectation?
Chair, I'm going to answer yes
I
and
think
no.
I know what your answer should be. Your answer has to be, when you put in your bid for that, you will say, well, if it's in Kudesport, this is what the cost will be. Since you haven't mentioned what other place in South Africa, I can only quote once I know which other place.
Well, but the issue being that it is not really a change per se if the RFP contemplated that the production place might be different.
No, it's not a change of place, but in terms of cost, it may make a difference.
It may make a difference.
Yeah.
It may result in an increase in cost, or it may result in savings.
In a decrease.
Yes.
Yeah, but you only know whether it's an increase or a decrease once you know where.
Indeed.
Yeah, yeah.
Then,
Indeed, Chair.
Did I guess your answer correctly?
Yes, Chair, 100 marks.
Okay.
I'll test that after the hearing whether he did guess it correctly, Chair. But you may continue, Mr. Mnyandu.
Thank you, Chair. As we have said, we have found that the advice that was offered by PwC was not carried through in the negotiations. The Chair will recall that the 2 points of advice that we gave evidence in respect of yesterday were that the OEMs were to be requested to justify their costs. And that secondly, if the costs were going to be prohibitive, then Transnet were to seek alternative measures where, loosely used in the report of PwC, additional costs would not be incurred. And we reached this conclusion having regard even to the fact that there might have been those concerns that were raised initially. In particular, we draw your attention, Chair, and take you back to the email correspondences shared amongst the negotiation team members, where Mr. Lahe writes to Ms. Lindiwe Mdletshe and says, here are my 18 areas of concern. She responds 2 days later and she says, here is the revised proposal. And then he responds further to say, well, my concerns have not been addressed, save for a different offer in relation to payment terms. So that engagement with the OEM, insofar as it doesn't, in the end, result in a justification of costs, means that there hasn't been an execution of the advice given originally by PwC.
Well, did you establish who at Transnet got to know about the PwC advice? Did you get to know a number of people who we can say did become aware of it at one stage or another?
Chair, we confirm that we were advised by Mr. Thamsanqa Nqajiane. His transcript is one of the appendixes to our report on relocation, that the then Group Chief Financial Officer was the one who spearheaded or sought the actual advice from PwC, and that he came back to them with the report from PwC and told them what it said. So certainly the negotiation team, prior to the conclusion of the contract, knew of the advice from PwC.
Yes, that's going to be important to take further.
Yes.
One, the proof that they were aware of it, but we also need to know whether the group chief executive or acting group chief executive, depending on when it was, became aware of it, and to the extent that it was not followed, what reasons why it was not followed. So it's just like the 9 million rand. We need to establish each and every person in the hierarchy of Transnet
Absolutely, Chair.
who got to know about it and what they did about it.
But one thing we can establish already, and based on Mr. Mnyandu's response to the Chair's question, if that report was, PwC report was contracted for by Mr. Anuj Singh, and that is the Group Chief Executive, you suggest?
Group Chief Financial Officer.
Group Chief Financial Officer. We know from evidence adduced by Mr. Mnyandu that Mr. Anuj Singh was part of the negotiating team.
He was the leader, actually.
Yes.
Of the
And
negotiating teams for the
Yes.
relocation.
Yes.
So already at least one member of that team was aware of the report.
A very
being
important
A very
member.
important member of that team.
What would remain is the GCE
Absolutely.
and the chief executive of the rail and
Freight,
freight,
yes.
unit. Yeah.
Yes, we will close that loop, Chair.
Okay, thank you.
Thank you, Chair. Chair, we have found that there was a breach of the PPM by the entire negotiation or negotiating team of Transnet. In particular, Ms. Lindiwe Mdletshe having been the lead interface insofar as she failed to deal with the concerns that were raised to the satisfaction of her colleagues and in the interests of Transnet. We've also found that the concluded agreement, or rather the agreement concluded between BEX and CNR is a very suspicious one. It brings into question and sharp light the question of fraud and corruption, which we get back to when we refer to our recommendations to Transnet. We make the point in slide number 35 that as an SCS, which is Supply Chain Services Official, and the lead interface for the negotiations, Ms. Mdletshe failed to adequately make use of an important internal structure, even when she had been requested by the Group Chief Procurement Officer.
And for the record, that structure is?
The Transnet Internal Audit.
Thank you.
Thank you, Chair. We have found that, as we already been highlighted, that all members of the negotiation team, those who recommended the cost, did not act in manner that would have been expected of senior officials within the organization of Transnet in their respective positions. Chair, in our recommendations and as a first base principle, which is something related to a point that the Chair has raised this morning on invoices, we have recommended to Transnet that the two OEMs be requested to provide a statement and debatement of the monies paid in respect of relocation thus far. We've also recommended that Transnet consider the whole issue of the variation orders related to relocation within the context of our findings in Volume 1. And to expand on that, Chair, just to explain, in our legal analysis of the variation orders, we have found that if the contract itself is unlawful for want of compliance with, amongst other things, Section 54 of the Public Finance Management Act, then everything that follows from it is unlawful. And so in the judicial review application that must now ensue, Transnet must seek a just and equitable remedy that also incorporates the consideration of the relocation variation orders. As a measure, in order to limit the exposure already suffered by Transnet thus far, we have specifically recommended to Transnet that they stop making all payments in relation to relocation. And finally, Chair, in relation to the CNR and BEX agreement that I said raises sharp interest and focus in relation to allegations of fraud and corruption, we've recommended to Transnet that they consult law enforcement agencies in order to take the matter forward. And that, Chair, brings us to the end of the presentation.
Thank you very much.
Chair.
You are done.
I am done, Chair. That brings us to the conclusion of Mr. Mnyandu's testimony before you, Chair.
Yes.
Subject, of course, to the filing and consideration of the supplementary statement in respect of the issues raised by the Chair.
Yes.
At that juncture, the Chair will make a determination whether Mr. Mnyandu need appear any further.
Yes.
Thank you, Chair.
No, that's fine. And there is also the affidavit that we talked about for the witnesses who came without an affidavit. It may well be that when one takes the transcript of their evidence, and one puts annexures, I'm not sure. It may well be that it might serve that purpose. I'm not sure. But if one could have an affidavit that basically repeats the evidence that they have given, but now puts it in affidavit form without the interruptions and everything, that may be very convenient.
We will look into that,
Yeah,
Chair.
if there is difficulty in one or another about that, I am open to another option that involves using the transcript.
Yes, Chair.
But when you talk about Mr. Mnyandu and Mr. Sedmedi, these are lawyers.
Yes.
Once they've got a transcript of their own evidence, they could even prepare that themselves and just bring you a draft of their affidavit, and you can just have a look. But it must be something that goes in accordance with the evidence they have given. And as an affidavit, it might then attach annexures. If it doesn't attach annexures, it could just indicate that the particular annexure appears in volume
Indeed.
what, at what page. Then it would be convenient. So at least with regard to them, you don't have
easier.
a big job to do.
Chair,
Yes.
if I may, on that, we will give the affidavits a first shot. We'll see if it works. Mindful of the fact that we don't want to make the chair's record unduly voluminous. But if there is a...
Well, it's the chair that prefers it that way.
The result might come with more 17 volumes, and I'm sure the chair wouldn't appreciate that. But we will give it a short, Chair, and if you permit us, should we run into difficulties, or
Yeah, if
should
there are
it...
difficulties,
the affidavits fail to address the point that the chair
Yeah.
raises, we shall revert, Chair, and we will consider other ways.
Yes, but I think with lawyers, it's much more easier.
I'll leave it to the
Because
two lawyers.
Your involvement will be limited. They can draw the affidavits themselves. They know what their evidence was. They know what documents they referred to in their evidence.
Indeed, Chair. I just need to check that both lawyers are here.
They are
to hear
here.
that. Yes, they are, Chair. Yes.
And they both agree.
They both agree.
Okay, thank you very much, Mr. Mnyandu, for coming to give your evidence. To the extent that there will be some aspects that still need to be addressed, you will address them together with the Ms. Silo. But thank you very much. You are excused.
Thank you, Chair.
Thank you.
Chair, we know we have encroached on the tea break somewhat, but we are done. The next witness is ready. He'll be led by my leader, Mr. Advocate Pretorius. I don't know if
Yes.
he would like to address you now or after tea when he takes the podium.
It doesn't look like he's keen to address me now.
Then it will have to be after 15 minutes, Chair.
So we'll take the tea adjournment. It's now 11:25. We will resume at 22:12.
Thank you, Chair.
We adjourn. morning, Mr. Pretorius.
Morning, Chair.
How are you feeling?
Well, at the moment, I'm feeling okay, but if necessary, I'll let you know, Chair.
Yes, okay. No, that's all right. Okay, thank you. The files that I have here, are they new files or?
No, those are old files. You can
Yeah.
set them aside. I'm about to hand up a new file.
Okay. Thank you.
Chair, the evidence under the auspices of MNS Attorneys continues. The author of Report 2B is Dr. Jonathan Bloom, and he will testify in respect of that report. May I hand up his presentation, which is Exhibit BB 8, small letter D.
Thank you.
It's based on MNS Report Volume 2B. I understand that during the course of his evidence, Dr. Bloom will, on at least one occasion, refer to the report.
I'm sorry, you just said it's based on MNS report
2B.
2B.
Yes.
Okay.
That report is in the files behind you, Chair, in Volume 8 of 17. But for convenience, I've asked that a further copy of the report be made with the same pagination number to save you having to look behind you. If you want that, I can give it to you. Otherwise, you can rely on the one.
Please give me that. That will be convenient. Zonaka. Just check. These reports are now mixed up. So there is 7 in there, which is supposed to be there. And 9 there, which is supposed to be there. But now, but just make sure that they are firing all the time. Yes.
Chair, the annexures and the report are volumes 8, 9, and 10, I'm informed, but you won't have to go there. What you have before you is sufficient for present purposes. Then, Chair, the evidence goes to an explanation and expert opinion of Dr. Bloom. We will qualify him in due course. But as a precaution, the legal team, the evidence leaders in relation to Dr. Bloom, requested this week that the Secretariat nevertheless notify those persons mentioned of the fact that that evidence has been given. That elicited a response from Nedbank. And after discussions between ourselves and Attorney Gerard Rudolph of Allen and Overy representing Nedbank, there was a request to place a statement on record, which, if you give me leave, Chair, I will do now. It's the following. According to the legal representatives of Nedbank, Nedbank was first provided with the MNS preliminary report, volume 2A and 2B, on the evening of 27 May 2019. Nedbank and its advisors are studying the report with a view to providing the Commission with its comment thereon as soon as possible. As I understand the intention of that communication, it's simply to state that they have not had enough time to respond in full, but intend to cooperate with the Commission by giving full submissions. What I haven't placed on record and don't intend to do at this stage is the fact that 3-3 notices were issued earlier and the fact that there have been interactions between MNS and Nedbank prior to the 27th of May but I don't want to go into any.
Okay, no, that's fine.
Then, Chair, if I may, by way of brief introduction, explain or state what Dr. Bloom is going to put before you, Chair. As you know, the purchase of locomotives from China, the 1064, or part of the 1064, involved a foreign manufacturer delivering locomotives across borders into South Africa. Transnet could not pay for these locomotives immediately. It had to borrow the money, firstly offshore in dollars, and then later locally a syndicated loan in rands in South Africa. The contracts involved payments to China North Rail and China South Rail in rands in South Africa. The money loaned offshore would be in dollars and exchanged across the border into rands when brought into South Africa. Further, Chair, the loan would not be drawn in one sum at one time, but in a series of tranches or amounts over a period of time. These are referred to as drawdowns. And over this period of time, obviously exchange rates would fluctuate and interest rates would fluctuate. Inherent then in such a loan arrangement are risks. There's the risk that the exchange rate could alter to prejudice the borrower, Transnet, or the other way around. There are interest rate fluctuation risks, that higher interest rates might have to be paid over a period of time if a floating rate loan was entered into. There are credit risks. There is the potential risk of Transnet, the borrower, being unable to pay the interest on the loan in some time in the future. And there's what is known as, and what will be referred to as, a further related risk, a contingent credit risk. And that is the risk that Transnet might be unable to pay because of external factors, a downgrade or a collapse in the economy, or something that might have the result external to Transnet, but also to Transnet, that it couldn't pay the loan. Those are all risks that are attached to the transactions that were entered into. And what financiers have done in their wisdom, Chair, they've developed a range of instruments to address these risks, some more complex than others. And Chair, the language attached to these risks, derivatives, hedging, contingent credit risks, and the like, is a foreign language. And the one of the purposes of Dr. Bloom's evidence is to facilitate an understanding of this so that our understanding can be used later in dealing with other witnesses and making submissions to you, Chair. So the evidence will seek to explain these financial instruments that are used to mitigate risk, hedging instruments. The evidence will also show how these hedging instruments and the transactions related Chair, just to save you the trouble, I've had this introduction typed out. I don't know if you want a copy.
Yes, yeah, please.
So firstly, Chair, the evidence will seek, this is at the bottom of the page, to explain the use of hedging instruments. Secondly, the evidence will seek to show how the implementation and use of these instruments were manipulated to benefit To prejudice Transnet, that should be, not benefit, and to benefit third parties. Thirdly, to show how the financial advisors involved benefited from these financial transactions. And fourthly, to place an opinion before you that, in the view of Dr. Bloom, internal resources could have been utilized by Transnet, making it unnecessary to outsource for these costly exercises. Once this and other evidence is given, Chair, the legal team and its investigators are obviously not limited to the MNS mandate. Our investigations and evidence will go further, and we will seek to build a picture of who made all these decisions. When were these decisions made? Why were these decisions made? Who benefited from these decisions? And to try and establish links between all these questions.
And I guess what knowledge they had in this sector. Did they have the right knowledge to make the decisions? Because one, if they had the right expertise, but nevertheless made certain decisions that may be inexplicable, that might point to an intentional act
Yes.
to prejudice Transnet. But if they didn't have the required expertise, that might not show intention, but it might show negligence or even gross negligence, but it might raise the question of why they made decisions in a field in which they knew nothing.
Correct, Chair.
Yeah, okay.
And in fact, Chair, what Dr. Bloom will help us with is to point us in the direction of those questions that we should be asking, and also begin to build up some picture of possible answers. And then the investigation team and legal team will build on those, hopefully to present before you a picture which might form the basis of findings that you may make, which go much further than just the transactions themselves. Finally, Chair, in accordance with the directive you've given this week, we will, in the course of the next few weeks, prepare an expert report in the normal form with expert qualifications and the like to present to you.
Yeah, no, that's fine. That's fine.
May the witness then be sworn.
Yes, but just before that, I think it would help if at the beginning of his evidence, I could just be alerted to certain specific terms that one needs to understand from the beginning that he may be using, that obviously I don't know about, not being in his field of expertise.
No, Chair,
so that I, as we go on, one knows there is this term,
Yes.
this is what it means, and so
We've
on.
tried to avoid in the first part,
Yes,
and that's not long,
yes,
the reference to any specialist term.
yes, yeah.
And at the appropriate time, we do intend to do that.
Okay, no, that's fine, as long as by the time they are used, I've been alerted.
Chair,
I
and,
know,
and
yeah.
I must say that for someone, including myself, that is not used to these terms, very often what an expert would do is be confronted with a question about the proper meaning of a particular term, and then use another technical term to explain it, which doesn't really help someone in my position, and I understand your position too,
Well,
Chair. So
yeah.
we will, and with your assistance, Chair, to stop us
Yeah.
when necessary, we will attempt to clarify
Well,
an understanding of these instruments?
Yeah. Well, Mr. Pretorius, that does happen, and sometimes it's a bona fide mistake on the part of the expert. Sometimes it's meant to show you how little you know. So,
In this field, I'm prepared to accept that we start from scratch.
and I'm sure other people say lawyers do the same.
Of course, we do.
Okay, all right.
It's just a different language.
Just a different language. The witness may be sworn in, please, or affirmation may be administered.
Please state your full names for the record.
Jonathan Zorach Bloom?
Do you have any objections to taking the prescribed oath?
No?
Do you consider the oath to be binding on your conscience?
Yes.
Do you swear that all the evidence you will give will be the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you.
Thank you very much.
Dr. Bloom, first up, would you tell the Chair of your qualifications? And Chair, in this regard, may I refer you to the green divider at the end of your bundle? You will see there an abbreviated CV.
Oh, yes, thank you.
Dr. Bloom, with reference to that, would you please tell the Chair of your qualifications?
Thank you. Chair, I hold a BCom degree with majors in statistics and finance from Stellenbosch University, a honors BCom cum laude from the same institution, an MCom cum laude from the same institution, a PhD in business management with a corporate finance specialization from the same institution.
Would you tell the Chair, please, of your experience in the field about which you're to testify?
So I'm sorry, so it's BCom from Stellenbosch,
That's right.
you said, and BCom honors cum laude Stellenbosch,
Correct.
and then MCom cum laude,
From Stellenbosch.
which university, Stellenbosch?
Yes,
Yes,
all the degrees.
and then PhD cum laude.
No, unfortunately, there's no cum laude for a PhD, Chair.
You thought you had enough, it's fine if you just get the degree. No, thank you, Dr. Bloom.
Your experience?
Chair, I've had the opportunity to consult on various financial matters to financial institutions in the financial services industry. Also, from a finance point of view in the development industry, where at Stellenbosch I held the position as Associate Professor of Real Estate Investment and Financing. And the idea behind that was that we prepared students for a Chartered Financial Analyst qualification, and I was part of the team that did that. So for the last 22 years, although I was part at Stellenbosch at that point in time as well, I had the opportunity to consult in the industry, and yeah.
Thank you.
You will tell the Chair of the various financial instruments that financiers use and institutions use to mitigate risk in transactions such as the loans involved in the purchase of locomotives from China.
That's correct, Chair.
Do you have experience in studying these instruments?
Yes, Chair. I investigated, as part of this assessment, the various instruments used and unpacked them to understand what Transnet did, or what the service provider that assisted Transnet did in the execution of these instruments. So the focus was essentially on the instruments used to hedge the risks related to the financing.
All right, we'll come to your actual work
Yeah.
and what you learned from that work during the course of your evidence. But the question I'm asking is a more general question. You have, and I may ask it again when the particular opinion that you express is relevant, but do you have general experience in the study and understanding of the use of risk avoiding instruments
I do,
in
Chair.
financing?
I do, Chair.
You were part of the MNS team that studied the transactions involved in Report 2B.
Correct, Chair.
Over what period of time have you been working on this project?
Chair, since September last year, and it continues.
And what was your brief in sum?
My brief consisted of several components. It started off by looking, interestingly enough, at the local content contributions and assessment thereof of the OEMs, specifically the China North Rail and China South Rail locomotive local content. It moved to understanding the advisory services that were provided through an LOI and an MSA. In other
What's
words,
an LOI and MSA?
the letter of intent and the master services agreement that was actually testified to in this commission by Mr. Sedemedi in volume 2A. And then after that, I moved over to understanding how several transactions were introduced in the financing of the vehicles and how the hedging of those of the risks associated therewith was done.
All right, you've already introduced a word in the foreign language in which you're an expert, hedging. Let's leave that for the moment.
Okay.
But for the moment, financial instruments used to mitigate risk.
Correct, Chair.
And I've, in my opening, mentioned these briefly, and you will deal with them in detail in due course.
Correct, Chair.
As I understand it, your evidence here deals only with the part, or that part of the locomotives transactions involving China North Rail and China South Rail.
That's correct, Chair.
And as I understand it, you've examined how the purchase of these locomotives was firstly financed. Is that correct?
Correct, Chair.
And you've also examined how the risks associated with the transaction, the loan transaction in particular, were dealt with. Let's just put it that way for the moment.
That's correct, Chair.
If we may then go to your report. And deal with what we've placed on record by way of introduction more methodically. At page 2, you have an introduction. Would you just take the chair through that, please?
Yes, Chair. This is a prelude to the actual work, but it's necessary to provide the context in which the work that I did actually happened. So the presentation deals with transaction advisory services, and as Mr. Pretorius indicated, it refers to 232 diesel locomotives from China North Rail and 359 electric locomotives from China South Rail. So as part of the introduction, Transnet appointed transaction advisors in 2012 to provide it with the transaction advisor services related to the acquisition of 1064 locomotives. And Transnet awarded at that time the transaction advisory contract to the McKinsey Consortium in July of that year. The scope of the contract was amended from time to time.
Okay, so before we can proceed, even before it enters into any transaction, Transnet appointed advisors to assist it in obtaining a loan and determining how that loan would work, as I understand it.
Correct.
And that transaction advisory contract was awarded to McKinsey in July 2012.
That's correct, Chair.
Tell the Chair of how that consortium was initially composed, please, because we will see in the course of time the development of a transfer of the work to particular institutions which are central to the investigative work of the Commission.
The McKinsey Consortium, Chair, was led by McKinsey Incorporated, the South African branch of the company.
You're at page 3, huh?
Page 3, correct, Chair. Comprising of McKinsey Incorporated as the main bidder, Letsema Consulting as the co-bidder, and then several subcontractors, Advanced Rail Technologies, Nedbank Capital, Edward Nathan Sonnenberg's ENS, Khoikan Young Incorporated, and Utu Capital.
You just control it. I'm on page 3.
Sorry. Sorry, Chair.
Yes, okay.
Then let's go to page 4, and we begin to see changes in who the transaction advisors are.
I'm sorry, this might be a question that has nothing to do with you. I just see that there is an indication of, at page 3, of those who were subcontractors. But I wonder whether they had been put in as part of the consortium from the beginning. But as I say, it might be something that you know nothing about, somebody else who would tell me about it.
Chair, you're correct.
Oh, okay, all right. Mr. Pretorius, is there something that somebody wants to do to assist the witness?
If you could just bear with me, I'm just concerned that the progress on the screen is not as it should be.
Yes.
What are you doing?
Are you in control? We've wrested control from we've wrested control from others over the screen, Chair,
Oh.
so we will take responsibility for any errors.
Okay. But I was concerned about the movement.
Yes, that's it, Chair.
It's been sorted out now.
I hope it has been sorted out. Can you-
Okay, all right.
Yes, I'm told it can.
Yeah, okay, because any movement to the witness while the witness is giving evidence, one needs to be careful about it.
I understand that,
Okay.
Chair.
All right.
It was entirely in order to
Yeah, if
place
at least
control of
I'm
the screens.
if I'm advised, if I'm informed, then it helps. If
Yes.
I don't know what's happening, and
Yes, Chair.
anybody watching might be thinking the witness is being told what to say. Okay, all right. Thank you.
Yes,
So,
I can assure you that that would be very difficult with Dr. Bloom.
I can imagine.
One would have to first learn a new language.
But are we okay now?
Yes,
Can
we are, Chair.
Okay, all right. Thank you.
All right. Can we go to page 4, please? Just explain at a very high level what happened to the sequence that you outline here,
Chair,
and particularly the composition of the financial advisors.
on the 22nd of August 2012, Transnet raised the conflict of interest between Letsema and Barloworld.
I'm sorry, Dr. Bloom.
No problem.
I do hear you, but maybe if you can just raise your voice a bit, that will help.
Certainly, Chair.
Thank you.
On the 22nd of August 2012, Transnet raised the conflict of interest between Letsema and Barloworld. It was based on this conflict that Transnet advised McKinsey, or the McKinsey Consortium, to consider the replacement of Letsema. At a date of appointment, the McKinsey Consortium excluded Letsema, and it was replaced by regiments.
Right. So the first entry of regiments into the consortium was to replace Letsema.
That's correct, Chair.
And then what happened?
And then subsequently, regiments would also replace Nedbank and UTU, who were a consortium on their own or a partnership on their own, due to the conflict of interest as a member within the McKinsey consortium, and this occurred on the 19th of October 2013.
Just a comment, and I'm not sure that you're equipped to deal with it, but ordinarily when entering into arrangements of this sort and appointing transaction advisors in such an important series of transactions, one would imagine conflicts of interest would be dealt with before the appointment of the consortium.
That's correct, Chair, because typically you would ask the consortium members, do they have any conflicts of interest? And then that would be, in other words, they wouldn't be able to participate as a consequence. So yes, you would sort that out, or you would address that right in the beginning.
And apart from asking, maybe you may be expected to do your own investigation of what may be in the public domain.
Absolutely, Chair. And it's all part of
something very basic, at least.
Correct. It's all part of the procurement process and the evaluation.
Yes. Okay.
And then if you would go to page 5, please. There has been evidence, and there will be more evidence, concerning a session that took place in February 2014. And the proprietary nature of that session. But without going into any detail, would you just tell the Chair, please, what happened then?
Yes, Chair. On the 5th of February 2014, McKinsey purported to cede their rights and obligations to regiments for the transaction. And that related to the 1064 locomotives. And what is important in this context is that regiments was now responsible for the whole of the advisory services.
So if one reviews at a very high level the sequence of events in relation to the appointment of transaction advisors, one will see that initially regiments were not part of the consortium, but over a period of time, in successive steps, came to be the transaction advisor.
That's correct, Chair.
And the details of the manner in which this happened and any implications for our own investigations and evidence that might have been the subject matter of other evidence.
That's correct, Chair.
What does Volume 2B? That is the report that you authored, I understand it.
That's correct, Chair.
What does Volume 2B provide?
It provides a technical analysis and comment of the transactions, the regular transactions concluded by Transnet on the advice of transaction advisors.
And that would be transactions related to the borrowing of money to finance the purchase of locomotives.
That's correct.
And the financial instruments used to mitigate against the risk involved in this loan transaction or these loan transactions.
That's correct, Chair.
So in other words, it's the product of the work of the transaction advisors to Transnet to say, this is our advice and this is the analysis on which it is based.
Yes, Chair, that would be a typical situation
Yes,
that
to
they would
expect
present.
from that kind of report.
Correct, Chair.
Okay.
So if you would just go to the second bullet then on page 6 and tell the Chair what your presentation entails.
Chair, the presentation and the work as well entailed the services and analysis of the services rendered by the transaction advisors, principally regiments, and the fees paid to them. That's the first part. The second part, the loans that Transnet concluded to purchase the Chinese locomotives, which covered, and I think this is important to provide context, because this is actually where it starts. A requirement existed for a loan of $2.5 billion US to finance the Chinese locomotives that we are talking about.
When you say CDB loan, what is that talk of?
It was the loan that was sourced from the China Development Bank in China, and that was for an amount of 2.5 billion. What happened subsequently is that that loan was split into two portions, 1.5 billion that was drawn down, as Advocate Pretorius also indicated in the introduction, and a further 1 billion that was reserved as a facility that Transnet could draw on should the need arise. There was, just related to that 1 billion rand facility, Chair, there were no commitment fees that Transnet paid, and we will see later that that was shelved in favor of what you, the last bullet on that slide, in favor of a 12 billion syndicated South African rand club loan.
Right, before you go on, the initial arrangement was that the loan entered into to finance the purchase of the locomotives from China would entail a loan from the China Development Bank in the amount of $2.5 billion.
That's correct, Chair.
Then there was a change of mind, and it was decided that only 1.5 billion rand would be loaned from China, from the CDB.
That's correct, Chair.
And that another loan would be entered into, which we've called the club loan, which was termed the club loan.
That's correct,
That
Chair.
was a loan entered into between Transnet and a syndicate of lenders, banks principally,
That's correct, Chair.
for the amount of 12 billion rand.
That's correct, Chair.
And then if you would go over the page to tell the Chair what else you're going to deal with.
Chair, what else is assessed is the risks associated with the loans and the processes to mitigate them. And there's specifically, as Advocate Pretorius also indicated, there's specifically 3 types of risks that we are interested in and that are applicable to the transactions. The one refers to interest, the movement in interest rates.
All right, so when I borrow money, I pay interest to the lender.
Correct, Chair.
If, well, in any situation, whether it's cross-border or local, those interest rates, as we know, fluctuate.
That's correct, Chair.
And why is that a risk?
Because, Chair, what can happen is that you borrow money at a certain rate, which is fluctuating, which is variable, and if interest rates increase, it would increase your cost of borrowing.
And then the second subheading there, fluctuations in the exchange rate, you will also deal with that.
Yes, Chair.
Why is that? Well, as we know, that would only be a risk if the lender is outside the country and the borrower is inside the country.
That's
Then
correct.
you have money crossing borders and exchange rates.
That's correct, Chair.
Why is that a risk?
As we saw, the money that was borrowed was from the China Development Bank, which was $1.5 billion. That money had to be transferred to a South African bank, and it arrives here in dollars, and because the contract with the OEMs for the payment of the vehicles is in rand, the money, the dollars had to be converted to rand. So if the rand starts to weaken, then the cost of that borrowing also increases because they would want their money back in the repayments on that loan, they would want it back in dollars. So that places the borrower of the funds at risk.
So if the exchange rate moves against the borrower or to prejudice the borrower, it could find itself in a position where it could feasibly no longer afford
That's correct, Chair.
to repay to the foreign lender.
That's correct.
Then the third category of risk is credit risk. And you talk of two categories of credit risk. What are those?
The first category is the
I'm
problem.
sorry, just before you proceed, please don't forget the question you were answering. I just want to go back to the answer you gave to the previous question. Does that, does the instruments that you are talking about to mitigate some of these risks arise from the fact that if the borrower in South Africa and the lender in China, if their agreement simply said, this is what you'll owe me, maybe you are going to pay me in 2 years' time, without making any other, including any other arrangement, the lender could end up being paid at a much, at a lower amount in value, in real value, or that's not really what it's about?
Chair, I think basically what it boils down to is that when the lender, especially a foreign lender, finances something in a currency other than their own,
Yeah.
then they would expect to obtain the repayments on that loan in the currency that they lent at. In other
Yes.
words,
Yes.
US dollars.
Yes.
So they wouldn't be worse off,
Yes.
if I can put it that way.
Yes.
The risk shifts entirely to the borrower, because the borrower is expected to pay in dollars, and therefore, if in this particular case, if the rand had to weaken substantially, that would result in a tremendous cash outflow for the borrower.
Well, so that makes it why it's important for the lender to specify that the repayments would be in their currency. And if they were to allow the repayments to be in the currency of the borrower, they might run a risk that the currency of the country of the borrower weakens, and then they end up getting repayments that are much less than the value that they lent.
That's entirely correct, Chair.
Yes.
In other words, but they would never do that,
Yeah,
because they
never
wouldn't
do
take
that.
the risk.
Well, there has been some evidence. I just can't remember the details. There has been evidence in regard to something in this commission about, I think, these transactions. I don't know whether it was about Eskom or Transnet, where the transaction was in a currency that was quite unexpected.
Volatile.
I can't remember.
Volatile?
I can't remember, but
Right.
The question when you saw it that you asked is, but why did they agree to use that currency? Because that's not what you expect them to do.
That's
I just can't remember the details. Yes, okay.
Thank you, Chair.
As I understand it, and by way of summary, Dr. Bloom, in this case, and in many other cases, the foreign lender, for example, the China Development Bank, says, if you want to borrow money from me, I will lend you money in dollars, but you repay me in dollars.
That's correct, Chair.
If you have a problem with the exchange rate, then you must deal with it.
That's correct.
And the borrower then in South Africa might be faced with a situation where the rand weakens. It has to, in effect, buy dollars to make a repayment of the loan from time to time, or repayments from time to time, and might find itself in financial trouble or difficulty in repaying the dollar amount
That's correct, Chair.
due to circumstances beyond its control. Correct?
Yes, Chair.
So what it says is, I have a substantial risk just arising out of fluctuating exchange rates.
That's correct.
They may move against me, right? I must insure myself against that risk. And that's what we're going to attempt to deal with in part of the evidence that you're about to give.
That's correct, Chair.
And if the, say, South African, the rand strengthens, that might or maybe not might, will benefit me. But that doesn't necessarily mean the lender gets prejudiced. Is that right?
That's correct, Chair. In other words,
Yes.
you'll be paying less
Yes.
because the rand is strengthened, so it's
Yeah.
working in your favor.
Yes, but the lender remains in the same position that they were, because it's their currency that counts for them.
That's entirely correct, Chair.
Okay, thank you.
All right. And you're also going to discuss the charges that the service providers charged for their services in relation to these transactions.
That's correct, Chair.
You say in the second bullet on page 7, and you've described how the services were initially to be provided by McKinsey Consortium and subsequently regiments. What, in sum, were the services that they were contracted to provide?
Chair, that related to the raising of the finance, in other words, accessing the finance for the acquisition, to also deal with or structuring the deal, in other words, in the negotiation of that loan, and other advisory services related to the mitigation of risk.
Right. So they would advise on how to obtain finance, capital raising, you call it,
That's correct, Chair.
how those negotiations should be conducted, and the final loan agreements should be structured,
Correct, Chair.
and how Transnet should deal with the risks that you've talked about so far in your evidence.
That's correct, Chair.
What insurance policies you need and how these should be structured. I use the word insurance policy very loosely, but it gives us an idea of what the third tranche of advice was about.
That's
But
correct.
that's all. There's no real coincidence between an insurance policy and a financial instrument used to mitigate risk, and we'll clarify that in due course. You deal on page 8 with fees at a very broad level, and you'll go into more detail later. What do you say there on page 8? Would you tell the Chair, please?
Yes, Chair. As previously discussed by other witnesses, an initial contract for the advisory services was fixed at an amount of 35.2 million. And it's important to note, Chair, the words in parentheses or in brackets where there was no performance fee payable.
Or no success fee.
Or
You
no
use
correct.
the word success fee later.
That's correct, no success fee. However, the role of regiments expanded, so too did the fees payable to it. That, if I can continue, on the contract value increased, in other words, the capped amount of 35.2 million,
That's fees for regiments.
correct,
Yes.
Chair, in December 2012, increased to 41.2 million in February 2014, increased further to 78.4 million in April 2014, and by July 2015, the amount that was paid to regiments was 265.5 million.
Right.
And just by the way, Chair, these amounts exclude VAT or tax.
Sure. So, what was it? Within 2.5 years, they had increased from 35.2 million to 265.5 million.
That's correct, Chair.
Yes. Somewhere in new regulatory instrument within Transnet, there is a provision that advisory services of this nature, in other words, professional advisory services, even in financing, should be charged out at an hourly rate effectively. Are you aware of that?
Yes, Chair, that's correct. And that is also the norm that advisory companies or firms charge their staff out, is at a hourly billable rate.
And just on the face of it, to advise on a limited number of loans and a limited number of financial transactions to mitigate risk, 265 million seems an extraordinary amount.
Yes, Chair, it is. It does appear to be excessive.
And you can say that from your own experience?
Yes, Chair, especially if it would be very difficult to, you would have to have a tremendous number of people at very high rates working on that contract for an extended period of time to get even close to that number. And as a consequence, that appears extremely excessive for the purposes.
But you will deal with that in your evidence?
Yes, Chair.
So if one looks at the information you've set out in the table on page 9, one can compare the total capital loaned by Transnet and the advisory fees charged by regiments and actually paid by Transnet. Would you tell the chair of that, please?
Yes, Chair, in RAND terms, the $2.5 billion that we've been talking about translates to 28 billion rand. If we take the fee paid to regiments, the 265.5 million, excluding that would represent about almost 1% of that loan amount. And as said, this is well above the capped fee of 35.2 million, which is, as indicated, that is quite excessive.
Just to revert to the makeup of the 28 billion rand, there was initial China Development Bank loan of 2.5 million rand. Only, sorry? 2.5 billion rand, sorry, I have a cold, so it may not have come across correctly. 2.5 billion rand.
Correct, Chair. Dollars.
Only 2.5 billion dollars.
Correct.
Right? Only $1.5 billion was actually utilized. And then another loan replaced the $1 billion. That was the 12 million rand club loan.
Yes, Chair, the 12 billion.
Right. On page 10, you deal with what you've termed irregular success fees. Please.
I'm sorry, Mr. Pretorius. Dr. Bloom, seeing that you are a numbers person, as I understand the position, an increase from 35.2 million rand to 265.5 million rand would be an increase of what percentage?
Chair, if you give me 1 minute, I'll tell you.
Okay, all right.
Chair, that would imply a difference of 754%.
754% increase
Correct, Chair.
in 2.5 years.
Correct.
Okay, thank you. Thank you.
On page 10, you begin to explain some of these, or some components of these increases, because there were various increases that happened over a period of time, and you deal with some of those in detail.
Correct, Chair.
Please tell the Chair what happened in April 2015, please.
That is when, Chair, that is when Transnet's Group Treasurer, Mr. Patolo Ramosebudi, submitted a memorandum to the Board Acquisition and Disposal Committee of Transnet, BADAC, noting for inter alia the following 2 points: the confinement of JP Morgan to hedge the financial risks, in other words, to mitigate the risks, which referred to interest rates, credit, and currency, and which emanated from the 1.5 billion CDB loan that was then back into South African rands. And there's a second part to the first bullet there, Chair, that refers to also lead and underwrite the equivalent syndicated ZAR loan of the US dollar. In other words, that is to arrange the loan for $1.5 billion. It's the same, so the one is to hedge the risks or to mitigate the financial risks, and the other is to actually negotiate the loan. So there are 2 points in the first bullet. In the second one, to also motivate the contract extension of 265.5 million, the number that we've just spoken about, for the appointment of Regiment's capital for an advisory or transaction advisory services and to support the Transnet 1064 Locomotive transaction. It sought to justify the extension of the contract by proposing a success fee of 166 million. And we've heard previously, Chair, that success fees and performance fees were not permitted. So this seems to be a bit irregular.
All right. We're now back in April 2015. As I understand the recommendation or the memorandum motivating approval of BADC dealt with the appointment by confinement, and the Chair has been told about confinement appointments of JP Morgan.
That's correct.
And they were to do 2 things. One, they were to assist and advise Transnet mitigate against the risks inherent in these loan transactions.
That's correct, Chair.
But also to lead and underwrite the equivalent syndicated ZAR loan of $1.5 billion.
That's correct, Chair.
Right? So it was risks and advisory services in respect of the loan itself.
That's correct, Chair.
And then there's also a contract extension to 265 million. The 35 million had by this time already been extended on occasion. You're not dealing with that.
No.
But
Chair.
you're dealing with an increase of 166 million, which allowed the full amount to reach 265 million.
That's correct, Chair.
And that, Mr. Ramosebudi said to the BADC, let's give them a success fee or a performance fee.
That's correct, Chair.
And you've stated that that wasn't allowed in the original contractual arrangement. What did the BA, isn't there a duplication here?
Well, Chair,
Or are we dealing with different loans?
no, we're dealing with the 1.5 billion CDB loan.
Right?
Only that loan in respect of these.
JP Morgan. And in relation to regiments?
In relation to regiments, that's the 265.5 million.
No.
Well-
What transaction advisory services are the subject matter of the contract extension?
In other words,
yes, I understand.
in other words, are we not dealing with a situation where 2 different people are asked to do the same thing?
Correct, Chair. In other words, they were paid to do that work under the transaction advisory contract. In other words, that was not the, there was no reason for the need to engage in a success fee arrangement.
But I think Mr. Pretorius may be asking, and that's part of what I also want to ask, is once regiments was there, could they not cover all of this? Or is this a part that they could not cover and therefore JP Morgan had to be brought in?
Chair, that could be a duplication. The That's possible, yes.
That's possible. Okay. Is it something that you might be able to speak more confidently on after maybe reviewing more documents? Because it would be important to know if it is indeed a duplication in terms of work to be done, or whether it is not.
Chair, yes, I can maybe just add to enlighten that point.
Yes.
That in this transaction, when JP Morgan was appointed, when they started this, Regiments was their supply development partner. So they were part of JP Morgan, and then it appeared that they were still doing other work and being paid. So what the arrangement between Regiments and JP Morgan was, I'm unclear about. But it appears that they did not have in terms of hedging or in terms of mitigating the risks, Regiments could not do that part of the exercise because JP Morgan had a very strong balance sheet. And in order to have sufficient financial muscle, you would need a firm such as them. So I will look into that, Chair,
Okay.
and come back to you.
Okay, thank you.
Right. Let's stay with the insurance analogy for the moment. We're going to ditch the insurance analogy in due course. But the insurer who insures against risk must have the capacity, the financial capacity, to meet its obligations.
That's correct, Chair.
And you say that's why JP Morgan was considered and appointed as for the moment, insurer.
That's correct,
The
Chair.
risk mitigator, counterparty. Right. But you say that Regiments already had a presence in that arrangement
As the supply development partner, yes, Chair.
to JP Morgan.
Correct.
So Regiments had a presence in both these series of arrangements.
It appears, sir.
But what did BAD decide then after this recommendation was put before it?
Chair, they decided, decided not to appoint JP Morgan to lead and underwrite the US dollar 1.5 billion loan. In other words, that one recommendation that was made to this committee was removed at that point. So the only thing that JP Morgan was mandated to do in terms of this approval was to essentially hedge or to mitigate the risk related to that loan.
So JP Morgan then was appointed with Regiments in the wings to deal with the risk mitigation aspect of this group of transactions that you're going to talk about.
That's correct, Chair.
And who was the lead underwriter, the leader and underwriter of the loans involved, with the 1.5 billion dollar loan?
Well, Regiments arranged that in terms of, or because BADAC did not approve JP Morgan's appointment for underwriting or lead and underwriting, that was taken over by Regiments. And who underwrote
But Regiments was already in the picture because of the transactions you've already described.
Correct. This was in addition to the work.
Okay. As the chair has requested, perhaps a thorough analysis of the agreements and arrangements
Correct.
between Transnet and its advisors will be included in your final report
Yes,
that
Chair.
we will present. But on the face of it, a question that arises, and I'm not sure you can answer it now or it has been answered to date, is there just seems to be a duplication in the recommendation by Mr. Ramasabudi, if one has regard to the wording you've used in your presentation. Because if you look at the first bullet, J.P. Morgan was requested to be appointed on confinement to lead and underwrite the equivalent syndicated Rand loan of $1.5 billion. And it seems that the same appointment exists in the second bullet and had already been made in terms of the arrangements you've already described.
That's correct, Chair.
Is that correct? All right. And if you would go over the page, please, to page 11, you there deal with the success fee or performance fee, and you make a comment. What is that?
Chair, as mentioned previously, no success fee, Transnet does not permit the charging of success fees, so no success fee should have been charged or paid as services performed as part of the transaction advisory services for regiments, as they had already been appointed, and this issue will be dealt with separately.
Okay. But there are 2 points you make. The one is that the Transnet policies don't permit the payment of success fees.
That's correct, Chair.
Or performance fees.
That's correct.
They're presumably too subjective and too random and incapable of precise definition.
Yes, Chair, it's essentially about what percentage you want, if I can put it that way, and what is the amount that a percentage is being applied to. So yes, from a success fee basis, it's a question of you take risk if you're doing it on that basis. In other words, if you're not successful in terms of what your mandate is, then you don't get paid. If you are, you do get paid. But that was not Transnet policy.
Yes, but in this case, the success fee was just one component of a much larger fee.
That's correct.
It's not as if regiments took any risk.
That's correct, Chair.
They just got an added success fee as a sort of bonus or thank you.
That's correct.
But anyway, you say 2 things, I think, or you have already said 2 things. One is Transnet policy does not permit success fees.
Correct.
And you also say that the original contractual arrangement did not permit a success fee.
Yes, Chair, that's true.
Okay, and then the second bullet, what do you say there?
Before that, just to follow this. So are you saying, as you understand Transnet's agreement with the regiments, it was that they would be paid for their services initially without any success fee? There was no success fee mentioned because Transnet policy doesn't allow that.
That's correct, Chair.
Is that right?
Yes.
So whether they had succeeded or not, they would still have been paid. Is that right?
As part of their
In
transaction.
terms of that kind of arrangement.
Correct, as part of their transaction advisor fee.
Yes,
Chair.
yes. So, but later on, what happens is that Mr. Petole Ramosebudi prepares a memorandum which recommends that apart from being paid what had been agreed, which would have nothing to do with success or failure, they must, in addition, be paid a success fee.
That's correct, Chair.
And you are saying that when one talks about a success fee in this context, a success fee generally applies if the basis is if you achieve your target, you will be paid. But this is what you will be paid. But if you don't succeed, you won't be paid anything.
That's correct, Chair.
So here we get a combination of the 2 regimes. That's part of the point you make.
Correct, Chair. As you correctly pointed out, the success fee is on top of the advisory fee,
Yes,
for which
yes.
they've already been paid.
Yes, and one should normally choose one or the other and not have both.
Correct, Chair.
Yes, okay, thank you.
Then you make an important observation, Dr. Bloom, in the second bullet on page 11. What is that?
Chair, in 2014, when the CDB loan was being negotiated and concluded, Transnet had a funding team that included 3 highly experienced funding managers and an analyst. Between them, they had cumulative experience of in excess of 50 years in fundraising in most capital markets. So as a consequence, one begs to ask the question, why was it necessary to engage an external party to do the work where the expertise and capacity existed within Transnet at that time?
And as I understand it, and you may say this elsewhere, it's not only your opinion. The capabilities and expertise that resided within Transnet had been recognized externally as well.
That's correct, Chair. Yes, because there's the people at, if I can put it this way, the Treasury Department and aligned with the funding team were recognized, and we'll see that later as well, in a survey as being one of the best treasuries in the world in 2010, which points to the fact that that wouldn't occur if the necessary capacity and skills was not available within the institution. So yes, one just wonders why was this particular situation allowed to occur.
What do Transnet policies say about that?
Chair, in terms of the Transnet procedures and procurement manual, the PPM, by leveraging third parties to lead, arrange, and negotiate the CDB loan while having a full capacitated internal debt-raising team. And I would like to, Chair, if I may, refer you to a page in the report.
You're talking of Report 2B now?
Report 2B. It's page 6864 on the left-hand page.
I'm sorry, Mr. Pretorius, I'm looking at what you gave me. That won't have the same page numbers with it?
Yes, the same page numbers have been put in.
Oh, okay.
And they're in the top right-hand column.
Okay, what's the page number, Dr. Bloom?
06864.
Mr. Pretorius, I only see a page with 06 on the last page cover, but what I have inside doesn't have
Right.
06
Chair,
pages. I've got 95, 81, 77, got 64.
Chair, if I could
Am I
assist.
looking at the right thing?
yes,
You are-
if one has the 2 pages in front of you, Chair,
Yeah.
so if one just turns it sideways, that the other way, Chair. So you're unable to read the one page next to the other page. When
Yeah.
you look at the top right-hand corner.
Oh, they
You'll see the pages
put the
there.
stapler there, so it makes it difficult to see the page number.
Yes,
Yeah.
Chair, we changed.
I think
Chair,
this-
can I assist? Can I give you another copy,
Okay.
which is not, where the page numbers are not obstructed?
Yes, okay, thank you. Take this one.
Page 6864.
6864, yes, Chair.
Give me a highlighter.
Are you going to need this copy or not really?
I've been given another copy, Chair.
Okay. Will your junior knit this one?
Perhaps we could take that
Yeah,
one
maybe
back.
take that one. Yeah, okay, thank you. I think it can be used if you know where the page numbers are, or you get the staple to be on a different corner of the document. Yes.
Okay, thank you, Chair. It's on the left-hand, in the left-hand page, on that double page, paragraph, I would like to refer to 16.2, which is amended Transnet Procurement Procedures Manual, version 3, dated 1 June 2015. And I would like to refer to the first paragraph, which is 16.2.1, and just read it by way of explanation. Chapter 8 of the said manual refers to the identification of strategic specialist units. But what is interesting is that in this particular manual, in the amended one, the Treasury is not included as a strategic unit. And therefore, in section 8.3, that refers to the compulsory utilization of specialist units, the manual states the following: the specialist units mentioned above must be utilized by other Transnet entities for required goods, construction works, and services falling within their scope. And this is important. The external market may not be approached for goods, construction works, and services falling within the strategic specialist units or division core competency areas. This would also include specialist services that are required, which may be performed by a particular internal function, and I use the example of group treasury and group tax. So, Chair, this just aligns with the point in 2014 when the CDB loan was being negotiated, that the necessary expertise was available, and in terms of the procurement and procedures manual, they were required to use their internal expertise, except for the fact that in this, as you can see, this was in June 2015, and that was prior to, so this was changed then when it came to further utilization of internal units.
Dr. Bloom, you've just quoted from the report, which has in turn quoted from original policy documentation of Transnet.
Correct.
In your final affidavit, your final expert report, we will obviously have to refer to the original document in force at the time these transactions were entered into.
Correct.
And what you're saying in sum is that where specialist units existed within Transnet, there was an express policy prohibition against going out to the market for those same services.
That's correct, Chair.
But is the point being made at 16.2 of the report, the one you have just read, or were you also making the point that at a certain stage the internal policy was amended in such a way that Treasury was excluded?
Yes, Chair. In other words, that would have permitted, if in terms of the PP manual as PPP,
yes,
the PPM manual as amended,
yeah,
that would have resulted in them having the ability to go out to the market,
yes,
because the strategic unit, such as Treasury in this case, is excluded.
Yes, but your understanding is that that exclusion was not applicable at the time of this transaction.
That's correct, because this was 2014.
Yes.
And this was 2015.
Yes,
Correct.
okay. Okay.
But, Chair, it will become applicable when we proceed further. That's why I've highlighted it here, so I can just refer you back to
Yes.
section 8.3.
Yes.
So we're past 1 o'clock, but perhaps if I could just finish this,
Yeah.
Chair.
Yeah.
So are you saying that that exclusion of Treasury, or let's put it a different way, which is more accessible to us at least, that the provision in Transnet policies which would have prevented going out to market was removed, certainly in respect of Treasury.
Yes, from the 1st of June.
And that was
2015.
relevant to further transactions that you're going to deal with.
That's correct, Chair.
So it's possible that someone within Transnet would have seen, we can't go out to market, we have to amend the policy so we can employ external advisors.
It appears to be so.
Is this a convenient time, Chair?
Yes, but I just want to say this before we adjourn. We just have to keep our eyes on certain things that we are getting as we go along. We have seen that in regard to the fees for these transactional advice services, an amount of 35-something million had been fixed, but then the amount went up to more than 700%, as I understand it, 700%. That's very huge. And earlier today and yesterday, I was hearing evidence of similar things where, I mean, we dealt yesterday with evidence that a supplier said, if we do this for you, Transnet, it would cost 9 million rand. But we know that ultimately it costs 600 and something million rand. So here we have that kind of situation. But we have had, I think, in regard to ESCOM, maybe with regard to Transnet as well already, situations where there is capacity within the entity, within a parastatal, for certain work to be done, but that work is given to an outside supplier in circumstances where, at least so far, we haven't had any evidence what was wrong with using internal capacity. And from what we have said, Treasury here, Transnet's own Treasury, had the capacity and had people who were internationally acclaimed as good people for providing the services that were now being given to outside entities at huge amounts.
That's correct, Chair. I think what is important just to note is that we are specifically talking about the funding side.
Yes.
We will still get to the use of
Yes.
the Treasury when it comes to the
Yes.
mitigation of the risk instruments.
Yes, but at least the funding side, there was proper capacity that could have been used.
That's correct, Chair.
Yes. Thank you.
Chair, may I just say that
yes,
we will, in the report, deal with the
with all of these
sequence
things, yes.
of appointments,
Yes,
and we will also deal with the sequence of cost escalations.
yes.
But they are also dealt with in Report 2A,
yes,
which
okay.
is
Yes.
not within the province of Report 2B, but we'll do it in any event.
Yes.
Chair, is this a convenient time?
No, that's all right. We'll take the lunch adjournment and we'll resume at 2:05. We adjourn.